If you're watching live, you're watching on Father's Day. Big day today. Glad we got some people out there. And I'm sure we'll get a few more, as we always do. YouTube Live number 16 out of 20 daily, unique, different YouTube Live presentations, all related to estate planning. Like to give you just the practical knowledge that you can take and use in your own personal circumstances. So got a lot to jump in. So I do want to talk just for a minute about Father's Day. If you've watched any of my other videos, you know I don't talk too much about my personal life. And the reason I don't is quite frankly because I don't like, when I watch other videos to learn, I don't like those other people who are making videos, spend, go on and on about their personal life when I went there to learn. But so I'm going to make a slight and really, really good children. And so I'm very, okay, big topic here. It's a topic that everybody seems to want to know about. Everybody seems to want to address it. The old Paul, how do I make sure my bank accounts don't get frozen when I die? Or usually it's asked in another way. Paul, if I go add my son to my bank account, then the array of questions comes. Can they get it when I die? If they get sued, will I lose my money? Is it their money when I die? Do they have to share it with my other children, my other heirs? Will it get frozen when I die? So there's all those questions. I wish I had a nickel every time I was asked a question related to the freezing or access to a bank account, either during somebody's lifetime or when they die. So that's what we're going to get to the bottom of. I'm going to give you maybe 5 different ways to structure it. You'll figure out perhaps which way is the best for you. But most people would prefer that at least one or more of their survivors, heirs, children, most people would prefer that someone have access to their bank accounts and those bank accounts not be frozen upon the death of the account owner. And I think most people want that because Happy Father's Day to you as well, Slim Dog. Appreciate the courtesy. Most people.
Monopoly Utility FP&L wants us to believe they are industry leaders. The truth? FPL and parent company NextEra are caught up in an FBI investigation for a shady, failed scheme to buy Jackson.
Whether those are expenses related to funeral expenses or service expenses or legal expenses, and most people who are kind of preparing to make it easy for their survivors, they don't want those survivors to have to dip into their own pockets to pay for those expenses that are, related to their mother, father, aunt, uncle, grandparent passing away. So it's an issue that just about everybody has, and I just want to make it clear what we're talking about on this video. One is we're talking about really bank accounts. Really what we're talking about is bank accounts and credit union accounts. I'm going to refer to them collectively as bank accounts because they pretty much have the same rules. What we're not referring to is brokerage accounts. Completely different set of rules on your brokerage accounts that you may have at Charles Schwab or Vanguard or Fidelity Investments or Merrill Lynch or Edward Jones or UBS or any of these other brokerage firms. We're not talking about that. That's where you have the investment rules apply and the investment account rules apply, which differ significantly from the bank and credit union account rules. So we're talking about bank accounts like checking accounts, savings accounts, even certificates of deposit that you have at the bank. Also, what we're not talking about is money market accounts at brokerage firms. So those fall under the securities rules. Many people have brokerage firms and it's like a checking account, but they call it a money market account at a brokerage firm. This doesn't apply to that either. And the rules that I'm going over, or the strategies that I go over, they also don't apply to the IRAs that you have at the bank. So many people at the bank, they have a checking account, they have a savings account, they may have a certificate of deposit, and then they may also have IRA accounts, individual retirement accounts, and those accounts, IRA rules apply to those individual retirement accounts, not necessarily the bank and credit union account rules that I'm about to go over with you. So just make it clear, but still, even though I said this doesn't apply, this doesn't apply, this doesn't apply, this doesn't apply, everybody has bank accounts. Everybody has a checking account. Many people have savings accounts, and many people have certificates of deposit. So that's what we are talking about. Okay, so I'm going to give you the different rules. And look, I love the live chat, you know it. So all my accounts, including brokerage, are tenants in common with wife. Should my wife be able to use those accounts upon my death? Good question, happy me. I'm gonna address that. The old tenants in common. So you know what? Let me address it just because I so favor the live chat. So all my accounts, including brokerage, which means you have brokerage accounts, are tenants in common with my wife. Should my wife be able to use those accounts upon my death? So I'm gonna give my best shot at answering it, but as a follow-up to my answer, I think you ought to contact the brokerage firm or the financial institution, because as I'm gonna tell you, don't ever rely on the lawyer to answer these questions. Rely on the information that you get from the financial institution where those accounts are held. And I realize brokerage firms are bound by all of the securities rules, but even though they all comply with the securities rules, many brokerage firms will have additional policies that you need to be aware of on these types of things. So, but I'm going to give you my best answer. For tenants in common, you know, it's not an issue here in Louisiana. We don't have that. We're probably the only state that doesn't have, but I know enough to be dangerous. So tenants in common, no, again, check with your brokerage firm, but I feel like if you have a brokerage account with your spouse or with your wife and it's titled tenants in common, and let's say you die and there's $100,000 of investments in that tenants in common account, I feel like unless the bank has some other procedure, your half of that account will be frozen, and then your wife's half of that she will have access to, but she'll need a probate court order to access your half of that account. Now, I'll tell you as a side note, I know in many states, married couples title their brokerage accounts joint tenants with rights of survivorship, which is different than tenants in common. Now, I know that when the state permits that and it's titled that way, then joint tenants with rights of survivorship means when one of the joint tenants dies, ownership of the account goes exclusively to the surviving spouse. So then the surviving spouse can access all of it after the death of the first spouse. But tenants in common is different. Check with your brokerage firm, but I think that's what we got going on there. Should my wife be able to use those accounts upon my death? And we're going to get into the bank account stuff here in a minute. So good question, happy me. I hope it helped. Let's move on. All right. So the 5 options that I'll consider on the bank account. One is to just kind of leave it in your name, and let's say you have a checking account, it's in your name only. Many married people that will have an account solely in their name. Maybe they had it when they got married and they just never made it a joint account. Maybe the husband and wife agreed to have separate accounts, and that's how they just like managing their family's assets. Or maybe you're not married and you just have an individual checking account like so many people do, or savings or CD, and it's in your name only. Well, if you just leave it at that, that's the kind of do nothing strategy. Then when you die, it's going to be frozen. So let's put a name. I'm looking at the television above my camera that talks about Bolton. He's on the headline there. So Bolton has a checking account, and Bolton dies. And Bolton may or may not have a will, regardless. Let's say he did have a will, and let's say he left things to prosecutor. So Bolton dies, he leaves his assets to prosecutor, and he names prosecutor as the executor of his estate. And so when Bolton dies, what's likely going to happen is as Bolton's funeral gets done and death certificates get prepared, and Social Security gets notified that Bolton died, and then Social Security stops any kind of bank deposit into Bolton's account, and through that, the bank finds out that Bolton's dead, and they immediately freeze Bolton's account. And so prosecutor can't get to it. Prosecutor has to go see a lawyer, has to get confirmed as the executor, which takes weeks or months. And then prosecutor will open an estate account, estate of Bolton at the bank. And then prosecutor will have the appropriate court orders to order the bank to release the funds to the estate of Bolton so they can be deposited into the estate of Bolton account with prosecutor as trustee. Sorry I used those names, it's what I saw on the TV screen on the wall. All right, so that's the kind of do nothing, just leave the account in your name strategy. Most people don't like that because it doesn't give access to the survivors for months or weeks or months until after the account owner dies. So what else do people do? The next strategy is to do what it's kind of the, I'm gonna jimmy this thing, I'm not gonna get any help, I know what I need to do, strategy, I'm gonna get around, I don't need lawyers to do this, I got this. That's the next strategy, which is take one of your survivors, one of your kids, one of your heirs to the bank, and you add that person as a signer, authorized signer on your bank account. So much confusion about that concept. So first, let me hit the issue on point. If Bolton has a checking account, I'm gonna come up with a better name, and he brings Donald to the bank and adds Donald as a signer to the account, does that mean when Bolton dies, Donald can access Bolton's checking account? And as you might imagine, my answer will be, depends on the bank. Most banks, from what I've seen, will permit Donald to access Bolton's bank account if Donald is an authorized signer, but they don't have to. And there are many banks out there that when they find out that Bolton died, even though Donald is an authorized signer on the account, the bank will freeze Bolton's account, and then that executor's got to go through the process of being confirmed and opening an estate account and getting the court orders to the bank